Hi, everyone, and welcome. My name is Neha Sangera, and I'm the Policy Director at Berkeley Food Institute. BFI is a policy, research, and education institute housed in UC Berkeley. We leverage UC resources in partnership with communities to shape a just food and farming system. Today's webinar kicks off BFI's fall webinar series, where we connect policy and research to explore key issues shaping our food and farming system. To give you a quick preview of what's coming up in our fall webinars, our October webinar will focus on recent policy approaches in California to reduce the consumption of ultra-processed foods. Our November webinar will cover the 2025 evaluation update for the California Farm to School Grant Program. And finally, our December webinar will explore climate solutions in agriculture. You can register for these webinars on BFI's website under the event page. And now for today's webinar on antitrust law and the food system. When a handful of companies dominate the grocery, retail, and agricultural sectors, it influences who gets to farm, what food gets produced, and how much people have to pay for this food at the checkout grocery line. In recent times, we've seen a number of headlines on the topic of fair and competitive markets in the food system. For example, last year, the Federal Trade Commission and several states, including California, sued and successfully blocked a merger between grocery retail giants Albertsons and Kroger. The FTC had argued that the merger would lead to higher prices for shoppers and reduced bargaining leverage for unionized workers. And this proposed merger came at a time when grocery prices were steadily rising. Since before the COVID-19 pandemic, grocery prices have risen 29% according to Consumer Price Index statistics. Also, most of you tuning in today have probably noticed the increase in egg prices at the grocery store, which have more than tripled in cost since 2021. While the egg industry groups have pointed to avian flu outbreaks as the main factor driving this increase in egg prices, large egg producers have experienced record profitability as egg prices have been soaring. For example, an egg producer which controls about 20% of the American egg market saw an increase in gross profits by nearly 230% compared to the year prior. Earlier this year, the Department of Justice opened an investigation to examine potential anti-competitive behaviors by egg producers. These are just two examples of why fair and competitive markets are important. Under open markets, farmers have more freedom to negotiate prices for the food they produce, workers have more power, and everyday consumers have more choices and fair prices. Our two panelists today are experts in the field of antitrust law and enforcement. Doha Mekki most recently served as the Assistant Acting Attorney General for the U.S. Department of Justice's Antitrust Division, where she led more than 800 attorneys, economists, and staff in enforcing the nation's competition laws. Before that, she served as the Antitrust Division's second in command, where she oversaw landmark antitrust cases across sectors including big tech, financial services, healthcare, housing, airlines, live music, and agriculture. Under her leadership, the division filed more monopolization cases than it had in nearly 4 decades. Doha now serves as a senior fellow at the UC Berkeley School of Law's Center for Consumer Law and Economic Justice. Welcome, Doha. Professor Christopher Leslie is among the top 5 most cited antitrust law professors in the United States. He has published more than 50 law review articles in leading journals and is the author and co-author of several major case books and the leading treaty IP and Antitrust. A founding faculty member of UC Irvine School of Law, he has also taught at Chicago, Kent, Stanford, Texas, and NYU, and served as the chair of the antitrust section of the Association of American Law Schools. Before entering academia, he clerked on the Ninth Circuit and practiced antitrust and complex business litigation in San Francisco. Welcome, Christopher, and thank you both, Christopher and Doha, for joining us at BFI for our webinar series. And with that, I will turn it over to Doha.
Thank you so much, Neha, and thank you to the Berkeley Food Institute for inviting me to join today and to partner with Christopher to talk about why antitrust and agriculture and really food systems go hand in hand. I won't hide the ball. There is far more content here than we actually have time to go through. So this is going to move really, really fast. So here goes. Okay, so why do we have antitrust laws at all? The antitrust laws go back to a set of concerns in the late 19th century. And you have a senator from Ohio, John Sherman, take to the Senate floor and give impassioned speeches about how monopolies, which are huge concentrations of economic power, not only bring commercial harm, but they're really inconsistent with our form of government. But we have Justice Brandeis talking about really the commercial and political linkages between monopolization in our commercial sphere and our political way of life. And he really gives voice more than many others to the need to deconcentrate the economy and the myriad benefits that are the second and third order benefits of deconcentration in the economy. And you also have the Supreme Court, our nation's highest court, giving voice to the benefits of competition, right? That's the core of the antitrust laws. But also like really giving voice to this idea that there are political, social, civil benefits to competition in our commercial sphere. And of course, this is one of my favorites. This is Justice Thurgood Marshall, who compares the antitrust laws to the Magna Carta and says they are as important to the preservation of our economic liberties as the Bill of Rights is to the protection of our fundamental personal freedoms. And so competition, so we all have the same working definition, is basically a process of rivalry. Whether it's on the buy side of the market for certain inputs, like a lot of agricultural products are, or whether it's in an output market, like the kinds of products and services that we're used to buying at the store. Competition really gives us benefits like lower prices. It can compel producers and service providers to give us better quality, to innovate more. When we're talking about working people, competition means often better wages in terms and conditions of employment. And I would say this has really been a fascination of the American people for a long time. This is one of my favorite. I guess it's not quite an original source, but it's a great piece of writing from the Atlantic magazine way back in 1881, where Henry Demarest Lloyd writes a long form piece about the Standard Oil monopoly. And that's probably one of the things that you think about if you are not an antitrust dork like me. You think monopolies and you think Standard Oil, you think AT&T, you might think about the Microsoft case or the recent Google case. But here's Henry Demarest Lloyd writing all the way back in the 1880s about the misery of life under John Rockefeller's monopoly. And it's really interesting here is he really assails the titans of industry at the time and notes that, and I quote, they're getting up corners in wheat and corn and cotton. And so, what's the high level takeaway here? You should know that the nation's farmers were really some of the earliest proponents of the antitrust laws and really saw the connection between the economic risks of a lack of competition and some of the political risks that I mentioned earlier in terms of erosion of our democratic institutions. And we'll have some occasion to talk through these risks in later slides. So what are antitrust laws? We get our first one in the Sherman Act in 1890. But as we'll discuss, there's really another set of laws like the Clayton Act, the FTC Act, the Packers and Stockyards Act, and later amendments to the Sherman Act that really matter a lot in terms of the antitrust enforcement in agriculture and food systems that Christopher and I will have occasion to talk about today. So very quickly, Sherman Act, its playground rules, no conspiracies, no ganging up, and sort of tilting markets in your favor to the exclusion of consumers. It's also our primary anti-monopolization law, right? So no monopolies, no attempts to monopolize, and you can't conspire to monopolize. The Clayton Act is the primary tool that we use to go after mergers, illegal mergers that harm competition, but there's a lot of other great provisions, including prohibitions on interlocking directorates, an express carve out for labor unions, and a prohibition on things like certain kinds of ties and exclusive dealing. Uh, the FTC Act gives us a claim for unfair methods of competition that is actually broader than the prohibitions in the Sherman Act. Uh, and then as I think might be most interesting to this audience, there's the Packers and Stockyards Act of 1921. So a little bit of history here. We talked about how the farmers were some of the biggest proponents of antitrust and an earlier version of antitrust laws that were really focused on an anti-monopoly tradition. And so by the late 19th century, you get these huge concentrations in the stockyards. And it's their nexus to the railroads that really allows them to grow and amass power. And so producers of cattle, of hogs, sheep, goats are relying on these like agents or dealers to get their livestock to market. And so the meat packers on the other side are a lot of the main buyers. Uh, but they're also running a lot of the slaughterhouses and selling to wholesalers. And so this is a theme we see a lot in antitrust law, where you have these dominant intermediaries who can squeeze farmers on the one hand and jack up prices at the grocery store and in retail settings. And so by the late 19th century, Congress started to notice that there was a real problem in our agricultural markets, and the big five meat packers are in the crosshairs. By 1905, they're found guilty of price fixing and allocating territories, which are actually criminal violations of the antitrust laws. But then they actually merge into the National Packing Company, and they're indicted again on criminal antitrust charges. Interestingly, a jury acquits, but the company is actually dissolved and divides itself into three companies to avoid civil cases. And so the spirit of this, the desire for fairness, the desire to make sure that huge agricultural titans of industry are not able to sort of buy up competitors, reconstitute, and sort of bring to bear to on markets the kinds of harms that we're concerned about is really a challenge that's persisted for about a century. Um, the Packers and Stockyards Act, again, is much broader. It's a competition statute, but it's much broader than any of the prior statutes that we've talked about. And so I've listed here some of the things that are prohibited. One of the most important is unfair, discriminatory, and deceptive practices, which is, as we'll have occasion to talk about, a real challenge in this part of the value chain in our food systems. You should also know that Congress was so concerned about the plight of farmers that it actually gives limited exemptions for agricultural cooperatives from the antitrust laws under something called the Capper-Volstead Act. And so, again, I think you can see a concern within Congress about the ability of our farmers and our growers to be able to join together and have bargaining leverage or countervailing power against these huge titans of industry, big ag, in many different kinds of agricultural industries. Um, Later, we get the Seller-Kefauver Anti-Merger Act in 1950. One interesting historical note there is that it's passed after World War II at a time when there was a lot of concern in the post-World War II years about the rise of fascism in Europe and Nazi Germany in particular, and concern about whether concentrated industry actually may have given rise or given more heft to the Nazi war machine. And so there were actually reports and tribunals that were convened to try to not only impose antitrust laws on post-war Germany, but to break up at least one very big conglomerate, which was the IG Farben chemical cartel. Later amendments, again, you see this colloquy You see courts sort of narrow the reach of these antitrust and competition laws, and Congress, every time it addresses the antitrust laws, give more power to enforcers. And here in the Hart-Scott-Rodino Act, Congress actually gives the antitrust agencies of the FTC and the DOJ the ability to review mergers before they are consummated, because of concern that it's really hard to unscramble the eggs after you get sizable mergers. So, just a few case studies. Uh, in 2022, actually, let me back up. I should say I spent 10 years at the Justice Department's Antitrust Division, and it continues to be um, truly the highest honor and privilege of my professional life. And when I had the privilege of serving as the number two and then the acting, we really focused on agricultural markets because we thought that they had been badly neglected. And there were all of these accounts that we kept hearing when we went out to talk to farmers and growers about really astonishing abuses that were happening in these markets. And so in 2022, um, we filed a lawsuit and proposed settlement against Cargill, which is a huge agricultural conglomerate, Sanderson Farms, and Wayne Farms. And we alleged two things. Um, we alleged that the poultry processing companies, amounting to something like 90% of the industry, were actually exchanging wage and benefit information for their slaughterhouse workers, who are an extremely vulnerable population, and that had subverted competition for their wages and benefits. At the same time, we alleged that the chicken processors were engaged in something called the tournament system, where they had outsourced so much of the risk of growing chickens to their growers, but were arbitrarily penalizing them. And so this is an industry practice that's well documented. People take out huge loans to grow chickens, and they are kept economically very vulnerable by some of the economic practices here. And so we imposed rules to make sure that there would be more fairness to these markets. So what happened? Some of the data intermediaries that facilitated these practices were banned from the industry. There was a court appointed monitor for 10 years. We secured something like $85 million for slaughterhouse workers that were harmed by the practices. And we imposed changes on base payments for growers so that they couldn't be subjected to the arbitrary and capricious practices of meat processors that deducted some of their pay, even as the growers themselves were taking on so much risk for the system. And so I think this matters for a couple of reasons. The first is that this is about labor markets and working people when we're talking about farmers and growers. It's sort of a specialized type of working person, and it was very important to us to make sure that the public understood that we would bring to bear the full weight of the antitrust laws when there are anti-competitive practices that hurt working people. The second thing is that this is the first time the Antitrust Division had sued under the Packers and Stockyards Act that we could find. So maybe the first time ever, but certainly the first time in recent memory. We also filed a lawsuit and proposed consent decree against Cook Foods. This was another Packers and Stockyards Act case. And so this was about illegal exit penalties. Again, the financial conditions that are imposed on the people who grow our food in America are often astounding. They are economically exploitative. And Cook Foods had been caught imposing these exit penalties on growers who tried to switch contracts with different chicken processors to raise their chickens. And so there was a consent decree where Cook Foods would be under the terms of a settlement with the United States for 7 years. They would be required to give money back to these chicken growers, and there would be mandatory compliance and reporting obligations. And so, again, it was really important to us to give money back to people who had been harmed by these practices. In 2023, we filed maybe one of my favorite cases that we did at the Antitrust Division against a company called Agristats. And Agristats had essentially facilitated the exchange of competitively sensitive information between and among chicken, pork, and turkey processors. The participants to the scheme controlled like 90% of the chicken industry, 80% of the pork industry, and 90% of turkey sales in the United States. We were joined by a bipartisan coalition of state attorneys general. I should say that litigation is actually pending. Agristats is trying to get the case dismissed on a summary judgment motion. And assuming they are not successful, hoping they are not successful, that this case will go to trial early next year. Um, we also did agricultural cases in the merger context. As Neha mentioned, the cost of food is outrageous in this country, and at least some of the explanation probably lies in highly concentrated markets that are really hampered by high market shares and mergers that allow companies to jack up prices to consumers. And so in 2024, Dole attempted to, I'm sorry, Fresh Express attempted to acquire part of Dole's packaged salad business. So these are just salad kits. Something like 85% of all Americans are buying salad kits when they go to the grocery store, and this would have reduced the number of providers to from three to two. And so they abandoned that merger, and we issued a press release explaining why this was a good outcome for competition, and why the division had expressed competition concerns about this particular merger. We also used our policy arm to advocate for other improvements in the agricultural system. As many of you know, farmers are required to be scientists and engineers and business owners, and the cost of repairing their equipment is astronomical. And so John Deere is facing a private class action involving right to repair. And so essentially, you buy a John Deere piece of farming equipment, it breaks down. Maybe you're subjected to a small network of authorized servicers. You're waiting a long time. And in the meantime, you have farmers across the country who are losing real money and harvest and yield as they're waiting for very expensive services and repairs to their equipment. When we were at DOJ, we filed an amicus brief, which is a friend of the court brief, and we were firmly on the side of farmers and rejecting some of the legal and antitrust arguments that John Deere had put forward. And finally, we worked with our partners at the U.S. Department of Agriculture to strengthen some of the rulemaking authorities under the Packers and Stockyards Act, and proposed three different rules to make sure that chicken growers, which again are a very economically vulnerable segment of this industry, were treated with more fairness and couldn't be really subjected to these unfair practices. And so you can see the three rules. There's a prohibition on deduction-based payment systems. They could get bonuses, but not penalties. We sought more transparency and capital improvement requirements, and we really sought a more muscular agriculture and marketing service at the USDA to oversee some of these rules. And so you can, if you dig into the details, you can see a connection between the Cargill-Sanderson-Wayne resolution that DOJ obtained and what later became the rule at USDA for this industry. So that was extraordinarily fast. There's much more to say about this part of the value chain. But if you want to learn more, you should know that there are great government authorities that are doing this work. There's the Antitrust Division at DOJ, the Bureau of Competition at the FTC, the Office of General Counsel and the Agricultural Marketing Service at the USDA. Every state has antitrust laws on the books and has the ability to file under the federal statutes. And there's always the power of we the people. Congress was so concerned about competition and antitrust issues that there's actually a private right of action. And so people who have been injured by antitrust violations actually have the power to hire their own lawyers and bring their claims to federal court. So I will leave it there and turn it over to Christopher.
Thank you so much, Doha, for giving us an overview of the foundational laws on the books that we have for ensuring fair and competitive markets. And before we hand it over to Christopher, I will just make a quick note that we'll have a short Q&A period at the end of this webinar. So if folks have questions that they'd like to ask Christopher and Doha, please feel free to add those questions in the chat right now, and we'll have about 10 minutes at the end to do Q&A. And I will hand it over to Christopher.
Uh, uh, Thank you, Neha, and thank you to the Berkeley Food Institute for inviting me. And thank you so much, Doha. That was a great presentation. Uh, so I'm going to talk about the last link in the food distribution chain, how consumers have access to groceries. And in particular, I'm going to discuss the relationship between food deserts and antitrust law. So food deserts are communities without access to a full service supermarket. They're generally defined by proximity to a supermarket. So in urban areas, neighborhoods that are more than a mile away from the nearest grocery store are considered food deserts. Many residents of food deserts neither own cars nor live close enough to public transportation, so they just don't have access to healthy, affordable food. Currently, America has 6,500 food deserts, and they exist in every region of the country. Estimates suggest that between 23 million and 30 million people live in food deserts. And even in those communities where a food seller is technically available, independent urban grocers typically charge 10 to 60% more than chain supermarkets. So paradoxically, consumers in low-income neighborhoods, those consumers with the least amount of money, pay the highest prices for their groceries, which reduces their purchasing power even more. This lack of proximity to supermarkets has significant health consequences because the diets of people that live in food deserts are significantly higher in sugar, salt, and fat, which translates into higher rates of heart disease, hypertension, and diabetes for residents of food deserts. Right now, millions of people are suffering, but it didn't have to be this way. During the early 20th century, urban residents enjoyed access to competitive grocery markets where fresh produce was available from several independent grocers in walking distance. But then the supermarket model emerged, and supermarkets drove small independent grocery stores out of business. Then, when in the mid-century, when African Americans and recent immigrants started moving into urban areas, white flight took place. Federal, state, and local governments all subsidized the exodus of white households into the suburbs. The government engaged in mortgage discrimination, highway development, and zoning restrictions that brought white households into the suburbs and left the inner city to be largely non-white households. And between 1950 and 1970, the population of the suburbs doubled from 36 million to 72 million people. And supermarkets soon followed suit, building larger supermarkets in suburban areas. Focused on the suburban dollar, they also closed their inner city supermarkets. But food deserts aren't the unintended consequence of supermarket society to shift their attention to the suburbs. That many of the food deserts in inner cities are the result of a premeditated strategy by supermarkets to prevent grocery stores from existing in inner city areas. So, for example, lack of space is one of the barriers to having supermarkets in inner cities because supermarkets require a significant footprint both for the store, the various departments, and for parking lots in some areas. One of the major reasons that appropriate sized spaces aren't available in many inner city food deserts is because when the supermarkets exited their old stores, they put restrictive covenants on the land that made it illegal to sell food from their former location for 20, 30, up to 50 years. These covenants created and preserved food deserts in major cities across the country, from Chicago to Vallejo, California, New Brunswick, New Jersey, Greeley, Colorado, all famously had food deserts because the abandoned supermarkets made it so it was illegal to sell food from their former locations. So you might ask, why would an exiting supermarket put a covenant on the land that prevents the sale of food? And the answer is because about half the residents of a food desert may have cars, and they'll be able to drive to the suburbs, and the grocery store chain wants to force them to drive to the suburbs. But for those half of the residents that don't have cars, they simply don't have access to fresh fruits and vegetables. The covenant is designed to encourage people to drive to the suburbs that can and to leave those that don't have access to cars to simply do without. In addition to these covenants, some food deserts are created or reinforced by supermarkets simply closing a store and leaving it vacant, not letting any store move in as they just simply occupy the land. This strategy in the industry is called going dark. And this going dark strategy isn't just limited to landowners. Sometimes supermarkets will lease this space available for a supermarket, get a covenant from the shopping center owner that nobody else in the shopping center can sell food under the idea that the supermarket will be the only one to sell food. But then the grocery store will abandon that location, continue to pay rent, and enforce the covenant that nobody can sell food, meaning that entire neighborhoods don't have access to groceries because the one place that is suitable for it, the supermarket is paying the rent and keeping it empty. My scholarship focuses on explaining how these food deserts can be seen through the lens of antitrust law. That, as Doha explained, antitrust is about creating competitive markets. That food deserts are often a failure of competitive markets. Um, to me, it's perplexing that food deserts aren't seen automatically as an antitrust issue because these covenants to restrict the entry of grocery stores are inherently anti-competitive agreements that should fall within Section 1 of the Sherman Act. Unfortunately, courts have had a blind spot when looking at food deserts as an antitrust issue. In part, it's because how we define markets. So, in antitrust law, to figure out whether or not competition has been injured, one of the steps is we define the geographic market to look at whether or not there's been anti-competitive effects in this market. When analyzing antitrust claims against supermarket restrictive covenants, courts treat the geographic market as the entire metropolitan area, so a major city and all of its suburbs. And then when courts look to see whether or not there's a failure of competition, they look at this huge area and say, no, there's lots of supermarkets, so there's not a problem. They don't understand that within that huge metropolitan statistical area, there's lots of communities, some that have lots of supermarkets and some that have no supermarkets because of the anti-competitive conduct by the supermarket chains that have lots of stores in the suburbs. For over 60 years, courts have been reluctant to define geographic markets as narrowly as neighborhoods. So, for example, when the Federal Trade Commission challenged Whole Foods' acquisition of the Wild Oats supermarket chain, the district court accepted the agency's definition of the relevant geographic market as competitors, quote, within a distance of 3 to 6 miles of their stores, roughly 16 minutes driving time. The assumption here is that everybody has a car, which just fails to understand how millions of people, especially millions of people in food deserts, live their lives. They don't have access to cars. So the fact that there's a grocery store 6 miles away is of no use to them. Many of these people are simply forced to buy their food either from fast food chains or from liquor stores. Um, in non-merger cases, antitrust courts too often define the relevant geographic market for supermarkets based on consumers that have cars. So, for example, in one case, Tops Markets versus Quality Markets, the Second Circuit rejected antitrust claims that challenged a supermarket's anti-competitive conduct in Jamestown, New York, including the dominant supermarket chain, which purchased the only land suitable for a competitor to build a supermarket. They bought that land in order to put a restrictive covenant on it that forbid food from being sold on that land, and then resold the land now that nobody could sell food from it. The Second Circuit defined the geographic market as a 7 to 10 mile radius around the entire city of Jamestown, effectively eliminating the monopolization claim because there were lots of supermarkets in that 10-mile radius. Decades later, Jamestown, New York is a food desert. There's no supermarket, and one can't be built because the only land that's capable of having it has an anti-competitive covenant on it. Um, so, what can antitrust do? Well, removing restrictive covenants on the land can help solve the problem of food deserts, but we have to recognize these as an antitrust issue. And part of this is educating federal judges in antitrust litigation how people actually live their lives, how millions of people don't have access to fresh fruit and produce, how they don't have access to cars. The failure to treat neighborhoods as geographic markets in the context of supermarkets ultimately distorts antitrust analysis in the courts. It makes unreasonable restrictive covenants seem reasonable. It makes monopolists seem like they're facing competition even when they're not. And it makes mergers seem like consumers won't be affected by the merger, even though we know that they will be. Um, One thing that we could consider doing is in the context of supermarket mergers. And Neha mentioned the recent attempted merger between Albertsons and Kroger's. Um, that one thing that courts can do when they're evaluating mergers, and one thing antitrust enforcers can do when they're evaluating these mergers, is ask for merger conditions. That if a merger is going to proceed, the antitrust enforcement agencies can ask for merger conditions. These are generally divestitures where individual stores need to be sold, but they can also ask for behavioral or conduct remedies. One of these might be to require large grocery store chains uh, to not enforce and not ask for restrictive covenants, that major stores should not be allowed to dictate where else food is allowed to be sold. And this would be one potential advantage of when mergers go forward to try to clear the landscape of these anti-competitive restrictions. Another thing that we can do is try to stop supermarket mergers. The economic analysis on this is pretty clear that when supermarkets merge in concentrated markets, the prices for consumers go up in a statistically significant manner. One of the great things about the recent challenges to the Albertsons Kroger's merger is both the federal court in Oregon and the state court in Washington both defined the relevant geographic market as narrowly local markets. And looking in those local markets, both the federal court and the state court recognized that there would be anti-competitive effects if you allowed the mergers to go through in those markets. Um, Given that the federal opinion is a published opinion, and hopefully the state opinion will be soon, hopefully this can start setting the precedent in the right direction of having courts look at markets more narrowly so that we can protect low and moderate income neighborhoods and not penalize them because they're within driving distance to a wealthy neighborhood that does have access to stores. One other point that we might get out of the recent merger is that after the federal and state courts stopped the merger, Albertson sued Kroger for breach of contract, saying that Albertsons violated its duty to Kroger to use all reasonable efforts and best efforts to get the merger through an antitrust challenge. And what Albertsons was saying, in effect, was the divestiture that Kroger's proposed, which was selling 579 stores to a company called C&S, which at that point had 23 grocery stores. The court said, well, no, that this is basically a wholesale company that owns 24 stores. There's no way that they could successfully absorb 579 stores and be a competitive threat. And Albertson said, that's right. There's no way that C&S could be a viable supermarket chain that could price discipline a merged Albertsons Kroger's chain. That's Albertson's argument in its brief in the breach of contract case. But in the litigation, the CEO of Albertson said, divesting the stores to C&S would absolutely fix any anti-competitive problems, and you should allow the merger to go through because if we divest these stores to C&S, it will be a viable competitor to us. Albertson says completely different things when it's trying to get the merger through versus when it's trying to hold Kroger through, complaining about this same divestiture package was doomed to fail. That we need to take with a grain of salt what major supermarket chains say when they're trying to do these mega mergers. And with that, I'm looking forward to the Q&A.
Thank you so much, Christopher, for sharing with us the huge challenge of restrictive covenants. I think a lot of our viewers are probably familiar with restrictive covenants in the context of housing and its impacts to affordable housing, but it looks like that is a mechanism that also impacts our ability to access groceries as well. So we're in the Q&A section now, and it's open and live, so if folks want to ask questions, please drop them in the chat. We have a few that we can get started with. There's one question for Doha. How has the current administration changed the power of or enforcement of antitrust law? Do you expect it to change or stay the same? Doha, we're curious what your thoughts are on the enforcement of antitrust and how that's maybe changed over time.
Sure. So, let me start off by saying that there is a long bipartisan tradition of either doing nothing or making things worse in food systems. And we tried very hard to turn that ship around. But I don't want anyone to be left with the impression that we fixed the issue. There was so much more to be done. And in fact, by the time we left DOJ, it had been our intention, and my colleague Michael Cadis gave an entire speech about this, but to reorient the Chicago office of the Antitrust Division to concern itself either primarily or wholly with competition enforcement in our food systems because we felt so strongly that the entire system from the farmers and growers to the retail purchase of food just suffered from very serious competition pathologies because mergers over 40 years had hobbled this industry, and that monopolies and oligopolies had been allowed to grow really unchecked, and that it had hollowed out communities, often, though not exclusively, in the middle of the country as a result. In terms of the current administration, I think we're all sort of witnessing what's happening to antitrust enforcement policy. I think there were nominees who kind of came in and talked about an interest in vigorous antitrust enforcement. But unfortunately, we have seen the wholesale pulling back of certain cases like Robinson-Patman Act cases against Pepsi, which was a very important legal doctrine and theory for smaller and independent grocery stores who really needed to be able to compete on a level playing field with some of the big box stores and larger grocery retailers. We have seen very little like meaningful enforcement in the agricultural space. And we've also seen a hostility to antitrust enforcers and competition enforcers at the USDA, really carrying on with some of the momentum that we had built up in the Biden administration. I saw recent reporting that the USDA Agricultural and Marketing Service had actually sent a letter disbanding a state enforcement program that we had helped to stand up. We viewed the states as our partners, and doing a lot of that work. Again, strong local communities are really the foundation of good, strong economies. And it was really disappointing to see the Trump administration pull back on that. We've also seen really disastrous implementation of tariff policy. And again, I'm not anti-tariff, in broad strokes, but I do believe in good industrial policy and sound implementation. And I think it's very clear that that has not been done. And unfortunately, America's corn and soy farmers are bearing the brunt of bad government policy. There's also cuts to hunger programs. I mean, I could just sort of go on, but I think the administration has taken this in the wrong direction. I don't want to be too doom and gloom. That just means that there's a lot of space for state enforcers and for private enforcers to do more in this space. And it's my hope that will follow from the very serious gaps that the federal government has left.
Thank you, Doha. We have a lot of great questions in the chat, so we'll try to get through as many of these as possible in the remaining time in our webinar today. The next question, maybe Christopher, you could answer this. To what extent are restrictive covenants an issue in urban areas? Are there cities who have done surveys on this? How many restrictive covenants exist? There's another question along the same lines related to what kind of data are available. So Christopher, could you share a little bit about the data that you used in your paper as well as other forms of data that are accessible?
Sure. So the data is largely anecdotal. There has not been a comprehensive documentation of this. We know that there are hundreds of these things. We know that some major supermarket chains like Safeway did this as a matter of course when it would sell property in inner cities. This is also one of the levers, though, that you can get during merger uh, challenges. So one of the things that either the federal antitrust officials or state officials can do is ask for discovery when a proposed merger happens. And certainly these were some of the documents that were requested from Albertsons and Kroger's is to give us a list of the restrictive covenants that you have imposed. But that still is not public information in a here is the list of it. Hopefully, the two states that issued their own challenges to the Kroger's Albertson merger will do something with that data. So hopefully, Washington State and Colorado State have this data and will publicize it or do something with it. It is public data, so it is in property records, but it's not indexed in any way that you can search for it easily digitally, and it's in the local county property offices, and so you need to go in and look through the records like laboriously at a time, and so it would require somebody that has funding and time and patience to go through all those records and document it, which is why it would be great to be able to use the instance of mergers as a way to get firms to just agree wholesale, we're never going to do this again, and we're not going to affirmatively try to enforce any of the ones that we've got. But we know it's a problem. We don't know the metes and bounds of the problem. I should also say we know it's a specific problem in some areas. Like I mentioned, in Vallejo, California, and in Greeley, Colorado, the Safeway went out of business. There was a food desert, and nobody had access to food, and everybody knew that there was a restrictive covenant on the former Safeway location, and nobody could come in and use that to sell food. So we know that this is a problem. We just don't know the extent of it.
Yeah, thank you, Christopher. And we have a lot of students on the call today, so maybe this will inspire some PhD to do a project on this topic. Our next question is from Beth Smoker, who's with the California Food and Farming Network, and I invite both Christopher and Doha to respond to this question. What are your thoughts on trying to support alternatives to large grocery industries such as community-owned cooperative grocery stores or even publicly owned grocery stores? Could these alternative forms of ownership, could they help keep large industry in check?
You want to start, Christopher?
Sure. I don't know if they will keep industry in check so much as they are one of the necessary policy responses to food deserts. When you've got communities without access to food, any way that you can try to bring food into those neighborhoods is a great approach. There have been good pilot programs on community-owned grocery stores and publicly owned grocery stores. It would be nice to see research that figured out what worked and what didn't work with those and try to scale it. because we've got 6,500 food deserts. Let's try to bring as many of those to the food deserts as we can.
I agree completely. I think it's a necessary but not sufficient condition to fix these markets. I hope one of the takeaways that we've made clear is that every level of the value chain in the agricultural sector, from the seeds and fertilizer to the growing of food and raising of livestock, to the slaughter of meat, to the distribution, to the sale of food to families at retail locations, including grocery stores, suffers from very serious competition problems that have not been fully addressed for the better part of a century. And so to start to address this problem, Congress will need to appropriate a lot of money to agencies to focus almost exclusively on these problems. We will need innovations in terms of corporate governance and different structures for the sale of products and services that we care about. We're going to need better policy. We will need, and not just better antitrust policy, but better industrial policy to make sure that these markets can actually deliver the benefits that all of us rely on.
Can I add a little to that? 'Cause I agree with everything that Doha said, but maybe part of it too is this has to be salient to Americans. That, as Doha correctly said, we suffer from a lack of competition at literally every link in the food distribution chain. So people complain about the high price of food, but I don't think they recognize that a fair amount of that stems from a lack of competitive markets, and antitrust is a necessary but not sufficient on its own part of bringing competition and thus lower prices and greater access to those markets. But voters, Americans need to understand the importance of antitrust in getting us there.
Thank you. Thank you, Christopher, for adding. Our next question is kind of along the similar lines, but thinking about what can be done from the perspective of states. The question is, what can the state of California do to investigate and mitigate the impacts of concentrated food and agricultural markets? Does the state have similar tools, such as the DOJ, when addressing competition issues?
I should say, for California friends, you guys are extraordinarily fortunate because you have a terrific state attorneys general set up right at home. The antitrust division of the Cal DOJ is led by someone named Paula Blizzard, who is a great partner to us on so many different kinds of cases. I should say the California DOJ can bring cases under the Federal Sherman Act, but California has a Cartwright Act and an unfair practices statute, and is actually in the process right now of recommending whether to write a single firm conduct law that will help at the state level to go after monopolies and other kinds of like single firm conduct that have really made these markets just hobbled by concentration, mergers, abuses of market power, and so forth. And so the states can do a lot. Again, they're underfunded, but never underestimate the state attorneys general. They can do a lot.
Agreed.
Great. Thank you, Doha, for that. We have a question that has to do with antitrust enforcement, but for multinationals and global monopolies. So the question is, I'm interested in anti-competitive behavior upstream from the farmers in the input sector and the global monopolies in seeds, life sciences, and fertilizers. The question everyone can see in the chat references a Supreme Court case. And the question is, if multinationals are not subject to antitrust laws, what recourse do we have?
It's a great and also super niche question. I think I recall this case. This was part of the vitamin C cartel, where I think there was essentially a generic vitamins cartel price fixing case. And one of the defenses of one of the companies was that it was essentially national policy that I guess sort of led them to engage in some of the anti-competitive practices. I would just say, as a general matter, that antitrust cases are highly fact specific. And so I do not read that case to actually preclude wholesale antitrust liability for multinational corporations. What is really important, though, is the nexus to the United States. So companies doing business in the United States that are subject to the jurisdiction of US courts must abide by our federal laws with a very, very narrow set of exceptions. I take the point that there are very serious global interconnected problems, particularly when it comes to seeds and fertilizers, where we see some of the geopolitical dimensions of trade and sort of how the business sort of affects food systems in the United States. And so I would go back to the earlier discussion. It's not going to be just antitrust law, although antitrust law is a powerful tool when used appropriately. It's going to be trade policy. It's going to be different treaties between the United States and foreign counterparts, diplomacy, and other specialties of law that are going to have to be brought to bear to bring fairness to these markets.
Let me add that to the extent that part of the purpose of the question was multinationals aren't subject to antitrust law, that multinationals are subject to federal antitrust law, and international price fixing conspiracies that get together and agree to fix the price of seeds, fertilizer, tuna recently, or any agricultural product often are prosecuted criminally, and there's civil litigation in the United States courts. There are foreign nationals in American jails for price fixing. That case involved a very unique fact pattern and defense, but for the most part, international price fixing, including the foreign members of international price fixing conspiracies, can be found and held liable for violating U.S. antitrust laws, so long as we vigorously and appropriately enforce them.
Thank you. Thank you, Christopher and Doha. We are unfortunately out of time. There's a lot of great questions in the chat, but unfortunately we can't get to all of them. Thank you for everyone that's joined our webinar today. We hope you found this webinar informative, and we hope that you're able to tune in to our future webinars later this fall. And thank you again, Christopher and Doha, for joining us. Take care, everyone.
Thank you.
Thank you so much.